lawyer needs to identify the root cause of the problems, of the anxieties of his client. And that stage must precede any effort, any endeavor to find a solution for the client. Now, in the current context, let me give you the example of a patient going to a doctor, and the patient shows symptoms of, say, common cold or flu. Now, the patient may not necessarily be infected with the COVID-19 virus. So, seeing just a few symptoms, a doctor cannot, or rather should not, pack off the patient to the hospital or to the ICU. This, of course, differs from place to place, and some places there may be protocols where a patient might be required to be hospitalized or whatever. But I'm saying that generally now, the trend in most places is that the doctors will analyze the symptoms, will see the severity of the symptoms, and then adopt a wait and watch strategy if required, advise quarantine and a test, and depending upon the result of the test and the complications, the doctor may advise either medication or hospitalization, or if required, admission in ICU. So why I gave you this example is that when a client comes to you, you have to take a call whether you should wait and watch, whether you should wait for your client's right to initiate any legal action, to fructify, to crystallize, to accrue, or without wasting any time, you should send a legal notice or a representation to the concerned authorities, or you should approach the court straight away. Now, if you are exercising a right too early, then the case may be premature and may be knocked off in the court. Similarly, if you are exercising a right too late, then your case may become infructuous and nothing may survive in the matter to be adjudicated. Let me give you an example here. If you become aware of your neighbor's intention to construct a garage in his property, and that he will encroach into your property as well, when does your right to initiate legal action crystallize or accrue in your favor? So as a lawyer, you have to take a call. Just when you come to know that your neighbor is going to construct a garage, you cannot say that your right to initiate legal action has crystallized. You may have to wait for your neighbor to begin the construction and then slowly perhaps encroach into your property. Only then you have a right to agitate your case before the court that, look, my neighbor is raising a construction. Knowingly or unknowingly, he is encroached into my property. So therefore, you then go to the court and you ask for a declaration of your right in your property, and an injunction to restrain your neighbor from raising any construction pertaining to the garage in your land. Now, drafting has huge relevance even at the stage of pre-litigation. When you are yet to knock at the doors of the court. Now, drafting at pre-litigation stage may not be very attractive and may not be even highly paying work, but nevertheless, it is of utmost importance because the draft that you prepare at the pre-litigation stage, whether by way of legal notice or by way of representation to an authority or simply an email to your opponent, you make out a case, you lay the foundation on which your client will eventually build his or her case. Therefore, I always advise people working with me that you should give a lot of importance to drafting even at the stage of pre-litigation. And you should always emphasize on a strong and a good legal notice before you initiate the legal proceedings in court. Now, a few things, based on my experience, a few things which I would like to highlight to all of you that you should always keep in mind when you start your careers are: one, clarity of thought and expression. Right? Such clarity can come across when you use short, simple, correct sentences. You should develop a knack of putting across things in an interesting manner. The person, whether it's a judge or whether it is an authority concerned who has to take a decision in your case, must not be bored after reading your case. It must be of some relevance, some importance, some interest rather to that person. You should also be clear about your client's right when that particular right has arisen, when it has accrued in your client's favor. Fourth, you have to demand something, that here is a right which my client has, and these are the violations of my client's rights, and in view of these violations, I demand that the violations should stop and whatever my client has lost with regard to such violations should be restored to him. So this broadly sums up my views of the importance of drafting at the pre-litigation stage. Now, after that comes the stage of litigation, when you actually decide to take your client's case to the court. Here again, your role as a lawyer is very, very important. You have to convince your client about certain realities. That judicial process by and large in India is time consuming. Keeping those realities in mind, you have to chart out the most effective recourse available to your client under law. Certain fundamental calls you have to take at the very threshold, like which jurisdiction you will be invoking, whether you will be invoking the original civil jurisdiction of the civil court, or you will be invoking the writ jurisdiction, or you will be, say, invoking the consumer court jurisdiction, or say jurisdiction under some special act like SURFACE or the Insolvency and Bankruptcy Code, or any other such special statutes. Then you have to also take a call on whether the court which you intend to approach for your client has the necessary territorial and pecuniary jurisdiction. So that also comes within the ambit of jurisdiction. Then, most importantly, you have to find out what is the relief that you can claim from the court which you intend to approach. And reliefs are also of different nature. There may be a final relief, right, which you may be asking for, and there may also be interim relief. The importance of interim relief lies in the fact that, if you don't get that interim protection from the court, then the lists may become infructuous, may become irrelevant. So as I was giving you the example of a neighbor trying to encroach into your land by constructing a garage, if you approach court pointing out how your neighbor has been building a garage and is trying to encroach into your land, then you will have to, if you go to court, you will have to ask for a relief of declaration and also an injunction restraining your neighbor from carrying on with the construction. So you will have to ask for an interim relief. Interim means during the pendency of the proceedings, the neighbor has to be stopped from carrying on with the construction. Now, such a relief is important because if he does not stop and he continues with the construction, then ultimately the relief of injunction might become infructuous, might be of no value, it will be academic for all reasons. So therefore, it is important to pray for an interim relief also. Of course, later on you can ask for demolition of the garage if you succeed. But it is always advisable that you should try and avoid multiplicity of proceedings. So from that perspective also, you should always pray for an effective interim relief, which will be effective for your client and also for confining the, or rather not expanding the scope of the litigation. Now, after identifying the relief that you'll be claiming, you will also have to then make the strategy of whether you have sufficient documents to approach the court, whether the documents which have been provided by your client are sufficient to build a sequence of events from which the judge or the court will gather the entire picture. So if there are some missing links, then it might be difficult for you to establish your case before the court. So therefore, the relevance of documents is also paramount. Now I would like to come to the Code of Civil Procedure, which is more than a century old now. And it is an act which, considering the span of time for which it has been effective, for which it has held the field, it has faced very little criticism and in fact has undergone very little amendments also. Now, a lawyer familiar with the Code of Civil Procedure can easily switch over to other offshoots of civil law. So therefore, I would always advise youngsters that you should keep in mind the importance of understanding the nuances of the Code of Civil Procedure from a very early stage in your career, and you should always try to understand the implications and the various interpretations that the courts have given to different provisions in the code. Now, since we are talking about drafting today, I would like to refer primarily to Order 1 of the Civil Code. Orders come in the first schedule. So I would be referring briefly to Order 1, Order 2, Order 4, Order 6, Order 7, and Order 8. Now, before I go specifically to all these orders, I'll just tell you what these orders are about. Order 1 talks about parties to the suit. Order 2 talks about framing of the suit. Order 4 talks about institution of the suit. So these are all Order 1, 2, and 4. That is parties to the suit, framing of the suit, and institution of the suit. These are very fundamental, and you should be familiar with these provisions before you even start drafting. Then comes Order 6, 7, and 8. So these three orders deal with pleadings, the plaint, and the written statement. So these are again very important, insofar as the contents of your drafting are concerned. So you should be familiar with those provisions so that you know what contents you should incorporate in your draft, what contents you need not incorporate in your draft. Now, let's go to Order 1 first. So as I said, this deals with parties to the suit. Now, Order 1 provides that there can be multiple parties, in the sense multiple plaintiffs or multiple defendants to the suit. Now, what the court will look at is whether the right, we again go back to right, whether the right which is alleged to be violated, the right which is alleged to be in favor of, say, a party, can also be claimed by the other co-parties. That is, if there are, say, multiple plaintiffs. So if plaintiff 1 is claiming a particular right, the court will also see whether the other plaintiffs can claim such a right or can claim an interest in such a right. If they can, then court can allow multiple plaintiffs to agitate the case. Similarly, insofar as defendants are concerned, the court will look at whether the right which is alleged or which is asserted or claimed against a defendant can be asserted against other defendants also. If such a right can actually be asserted or claimed against other defendants, then court can permit there to be multiple defendants. Then you have to also examine insofar as multiple parties are concerned, you also have to see the scope of the relief. Whether the relief that is being claimed in the plaint can be claimed by all the plaintiffs, and similarly whether the relief that is being claimed can be enforced against all the defendants. So all these factors need to be kept in mind by the court while allowing there to be multiple plaintiffs or defendants in a particular case. Now, though a court might allow multiple plaintiffs or defendants to fight a litigation, but it does not necessarily follow from this that the judgment will be in favor of all such plaintiffs or against all such defendants, or vice versa. So it is up to the court to decide ultimately after hearing after the trial and after hearing arguments as to in whose favor actually the judgment needs to be given or not given. Now, I would like to mention something about class action, which also comes in Order 1 itself. Class action means where a representative suit can be filed, where a particular party initiates the litigation in court, but he claims to represent all other similarly situated parties who he seeks to represent. Now, let me give you an example. Nowadays, you hear of a lot of litigation pertaining to complaints of flat buyers against builders. Now, there's a provision under the Consumer Protection Act also, which actually draws its source from the C.P.C. Now, that provides for class action. And one flat buyer might raise a complaint before the consumer court, pointing out that, say, the date of delivery of his flat was 2017, but till date he has not got possession of the flat. Now, other buyers also will be similarly affected by the failure of the builder not to give possession of the flat. But other buyers, for whatever reasons, may choose not to come to court. So in such a case, the party who goes to court may say that this may be treated as a class action because all buyers are similarly aggrieved. In such a case, what the court does is they will issue notice to notice of by way of publication in a newspaper having circulation that all buyers who by these causes may implead themselves in this particular suit if interested. So after that, it is up to them to whether to implead themselves in the suit or not. Now, class action is something which is very common and popular in US. There are a lot of cases where they will invoke class action and file cases where the issue, where the list affects multiple people. But in India, it's not very common and popular, but still there are a lot of cases filed, at least in the context of grievances of flat buyers against developers. Now, Order 1 is important from one more perspective, that it gives the power to the court to add or delete parties. Now, you may have, all of you who have studied the C.P.C. Would be familiar with the concept of misjoinder or non-joinder of parties. Now, misjoinder or non-joinder of parties does not really affect the maintainability of the suit, but if a necessary party, if a party who is necessary to the litigation has been left out, then that may actually be a serious defect in the suit. Now, let me go back to the example which I gave you earlier regarding the construction of a garage in by your neighbor. Now, say for example that construction is being raised by a developer. Now, you file the case against the developer, but not against the neighbor. So that suit might be contested by the developer, saying that, look, you have failed to implead a necessary party, that is your neighbor, who's the owner, who's the person who has title to the land. So by pointing out this, he might raise questions as to the maintainability of the suit itself. So similarly, say if you're initiating litigation before the court, challenging the promotion of, say, a colleague. Now, you have challenged your employer. Say somebody works in PWD. PWD has given a promotion to your client's colleague, by which your client has been superseded. Now your client challenges the promotion. Now, in the petition, you have made PWD a party, but you have not made your colleague a party, your client's colleague a party. In that case, the PWD might raise an objection, or the court might also raise an objection that you have not completed a necessary party. So that by and large covers order 1. So I'll go to order 2 now. So see, these are fundamental aspects which one needs to be careful and conscious about before drafting. So though these may not help you much insofar as how to draft a case is concerned, but these are so fundamental and so linked with drafting or filing pleadings in court, that without some basic knowledge about these areas, your draft, no matter how good a draft you prepare, such defects might fail scrutiny by the court later on. Now, order 2 also says something very important, that you must raise the entire claim. That is, you cannot raise part of your claim before the court and choose to ignore another claim. Or, in other words, you have a right today to, say, ask or recover arrears of rent from your tenant for the years 2018 and 2019. Now, you have filed a suit for recovery of arrears of rent, in which you have asked for rent for the year 2019, and you have left out 2018. So, by relinquishing your claim insofar as 2018 is concerned, you will be barred from raising the claim insofar as 2018 is concerned, even at a later stage, unless the court permits you. So that is the basic premise of order 2, and this is founded on the principle that the parties must avoid multiplicity of proceedings, and for that reason you must include your entire claim. Order 2 also deals with joinder of cause of action and cause of action also. Cause of action is something so fundamental in litigation that you should understand the basics relating to cause of action in a way that will, so that you are never in doubt while filing a petition in court. Now, insofar as joinder of cause of action, for that you can also, I can go back to that example which I gave you regarding case filed by flat buyers against builders, where similar cause of action, right, exists in favor of multiple flat buyers. So the cause of action can be joined by the court, and multiple parties can be allowed to plead and agitate their case before the court. Now, let me just also highlight what cause of action means. Now, cause of action appears in the Code of Civil Procedure, but it has not been defined, because the courts, through multiple judgments, have highlighted time and again what cause of action means. So, to put it very simply, it means the bundle of facts which entitle a party to a relief. So, So it is the link or the nexus between the facts, which have to be material facts, and the relief which you are ultimately claiming for your client. So it's like the umbilical cord, basically. You have to establish a cause of action to seek a particular relief in court, and without a cause of action, you cannot go to court, and the cause of action must have arisen. So if the cause of action has not arisen, then again, as I said, your case might be premature in nature. Now, so that takes care of order 2 also. Now let me just point out order 4. Now order 4 is actually, it just mentions that a suit is considered to be duly instituted only if a plaint is presented in duplicate to the appropriate court and complies with rules in order 6 and order 7. Now order 6 by itself, order 4 by itself does not lay down any procedures, but it says that a suit to be duly instituted in a particular court must comply with the rules provided under order 6 and order 7. So that is the link, in a way, order 4 is the link between order 1 and 2 and order 6 and 7. So unless you are able to make sure that your plaint is compliant with all the rules envisaged under order 6 and 7, your plaint will be defective and the court may not even entertain it as a suit. So now we have to go to order 6. Now order 6 is very, very important from the standpoint of drafting a plaint. Now, before you understand what the implications of order 6 are, you should refer, according to me, to the appendix A, because appendix A to the C.P.C gives structure of the plaint, how it has to start with the title of the suit. Then you go, in the title of the suit, you have to give the court, the name of the court which you are approaching, the parties to the suit, that is Mr. So-and-so versus so-and-so, that has to come in the title itself. Then you give a description of the parties, where you put the name of the party, say a particular XYZ company, having registered office at so-and-so, and having a corporate office at so-and-so. So these details must come in the second heading, that is the description of the parties. Then you come to the body, the main body of the plaint, where you deal with introduction and description of the facts. Now, how you should put in your facts and other things, I'll come to in a bit later. So, in the body of the plaint, after the introduction and description of facts, you have to deal with limitation, that your case is within limitation, or even if it is not within limitation, there is some provision in the Limitation Act which enables you to file the case, even though it may be beyond the periods prescribed under the schedule to the Limitation Act. Then there has to be a paragraph which summarizes the facts which give cause of action to your client to approach the court, that particular court, and that court has the jurisdiction. So cause of action and jurisdiction, that has to follow limitation. So after the paragraph on cause of action and jurisdiction has to come the reliefs. What are you asking for? Are you seeking a declaration of your right in a particular property? Are you seeking an injunction? Or are you seeking recovery of some outstanding dues from the defendant? along with interest, along with damages? Or are you asking for some damages for certain losses that you suffered on account of lapses, breaches on the part of the defendant? Or are you asking for some liquidated damages prescribed under the contract? So all that has to come in the relief section. Then comes, the rules under Order 6, which deal with what you should mention, what you should plead in the plaint. To put it very briefly, what you should plead is material facts. You need not give evidence in the plaint. A subsequent stage in the suit comes where you lead evidence by way of affidavit, and you can also, your witness can depose and he can be cross-examined, and the other side's witness also can be cross-examined by you. So that stage of evidence comes later, but here at the stage of drafting the plaint, what you have to bear in mind is that you have to highlight what are the material facts based on which your client is entitled to the relief which you are asking. So therefore, I would say it is bare minimum that you must be familiar with the rules of Order 6 before drafting a plaint or a written statement in the suit. Now, each allegation which you're making, insofar as the material facts are concerned, must come in separate paragraphs, consecutively numbered. And say if you're alleging fraud, if you're alleging misrepresentation, undue influence, then you must give necessary particulars. You may not give the evidence, but you have to give necessary particulars like, the dates, or say pleading a fact pertaining to a particular document, or the effect of a particular document, or the effect of, or what the contents of a particular document say. So you need not necessarily extract the whole contents, but you have to put your case in a way that, if say, for example, you have been misrepresented by the defendant. So you will have to give the sequence of material facts from which the court can understand that, yes, the plaintiff has been misrepresented. Then another relevant rule that Order 6 deals with is verification and signing of the pleadings, the signature of the pleading in the pleadings, and the affidavit also. So these are fundamental because the party who is authorized to sign the plaint must, at the foot of the plaint, verify each and every paragraph, and must mention also the paragraphs which are based on his knowledge, and must also verify the paragraphs which are based on knowledge that he has inferred, or rather what he has inferred from the documents and record and other things. Now, another important aspect which is highlighted in Order 6 is regarding amendment of pleadings. So there may be numerous circumstances on account of which, after you file the case in the court, you may require to amend the pleading, amend the plaint. So Order 6, Rule 17 provides for right of the plaintiff to, not just right of the plaintiff, even the defendant can also amend the written statement. So, but you have to make out a case which calls for amendment, which warrants amendment. So for that, what the courts have said, and the way Order 6, Rule 17 has been interpreted, says that you have to make that amendment because that would help in advancing the cause of justice and will enable determination of the real questions in controversy between the parties. So these principles you have to keep in mind, so that after filing of the case, there is something for which you need to amend the plaint,